Division 1 is now in session.
Thank you. Please be seated. Good morning. This is time set for oral argument in Gwynn Antison et al. Versus Red Mountain Med Spa LLC. Our case number CV140389. Each side is allocated 20 minutes for oral argument. If appellant wishes to reserve a portion of that for rebuttal, sir, you may do so, but you'll have to keep track of your own time with the timer at the podium. I would again remind folks in attendance to make sure that their cell phones are off out of respect for counsel so our presentations aren't interrupted. We have read the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to the court's website and YouTube. So please, as you approach the podium, tell us your name and the party that you represent. With that, Mr. Peterson, you may begin.
Good morning, Your Honors. Art Pedersen, Gabriel Praz, and Michael Wright on behalf of Red Mountain. I'm going to kind of cut to the quick here. To me, this is a statutory interpretation case and really nothing more, nothing less. There's some other issues raised in the briefs, but I will only hit a couple of those. And when we get, as the court is well aware, since we are talking about statutory interpretation, this is a de novo review. Nothing from the trial court has any impact in that regard. The Arizona cases are clear in terms of statutory interpretation. We cited Wyatt versus Waymuller for the proposition that the primary principle of statutory interpretation is to determine and give effect to the legislative intent.
Well, that's okay, counsel. I understand that. Fair
Okay.
enough. Let me tell you my problem with this. And I'm speaking for me. It seems to me the legislature had several intents. They've made pretty clear in the language of the statute and in the preamble, which is, one, they don't want judges coming up with bases for wrongful termination actions. Two, they want to reaffirm that the presumption is it's at will. And three, that yes, you can bring a cause of action based on a written contract for wrongful termination or anticipatory breach. We'll include that because that's a breach action. Based on a written contract. Under certain circumstances. And the one circumstance we have here is if there is a specific durational period in the agreement. And my problem is, I think the legislature was being pretty clear. It was saying, if you put a specific period in there, saying this is going to be a 6-month contract, this is going to be a 9-month contract. We're not talking about it's going to be $24,000 per year or something like that. You put in a durational period. It's no longer at will. Nice. I think that's nice and clear. It gives the employers knowledge of what they have to say. It gives employees knowledge of what they have to say, what their rights are. And then we come to what Red Mountain did. And it said 90 days trial period. And so there are a couple of ways to approach this. One is that it doesn't fall within it's still at will as a matter of law. The other is that it's no longer at will because you have the durational period, and that's all the plain language, all it requires is that durational period, and it's no longer at will. Third is that it creates a fact question as to whether it falls within the statute or not. And as I understand it, your argument is, doesn't matter if you had trial period. It's still, if you say 90 days, as long as you have that word trial, it's at will. I understand their position is, they have the 90 days. We don't care what you do when you say trial. It says 90 days. It meets the statute. I don't see anybody arguing that this could be a fact question for a fact finder to determine whether it falls within the statute or not. And so what I'd like you to do is say, well, why isn't it a fact question?
All right, Your Honor, let me back up a step. I think your analysis would be spot on, but for specific language in the statute that says the written contract You must have a written contract to the contrary of at-will employment setting forth that the employment relationship shall remain in effect. Your interpretation effectively, and the trial court's interpretation effectively deletes that language from the contract.
Well, how so?
Because the contract did not state that you have two corollaries here. The contract must state it shall remain in effect for that period of time, or alternatively, the contract must state that neither party has the right to terminate the agreement. The emails here don't say either. It's no different that if you offered me employment for a year, I say yes. There has been no agreement between us in writing that says the at-will presumption was negated.
So are you saying that an agreement to get it to be continual to meet the statutory requirements, so it's not at will, it has to actually say this is not an at-will contract?
No, it doesn't have to state that, but it must state that this contract shall remain in effect for this specific period of time.
What if it says, I am hiring you for a year, beginning August 1st, 2015, ending July 31st, 2016? At will, under the statute, or not at will?
I think it has to state under the statute that it shall remain in effect for that period of time. And the reason I say that is the Taylor case, authored by now Vice Justice Palander, and Johnson, in which they analyzed, well, can you get, by implication, by inference, can you draw the factual conclusion outside the document that says neither party can terminate? And that same analysis from Taylor applies in this situation.
Let's assume that we conclude that the exchange of emails constituted a contract and that they're signed, as the statute requires, and that the agreement for a trial period of 90 days constitutes a express term of length of employment under the statute. My question is, what is a trial period of, what does that bring to this contract? Does it mean that, did the parties agree that she had 90 days to prove herself? She makes a mistake on day one, her performance will be reviewed on the basis of the other 89 days as well? Or does it mean that she could have been terminated on day one had she made that mistake?
That's a good question, Your Honor. And the analysis, I think, starts with Damas, the Arizona Supreme Court decision that talks about at-will employment. At-will employment allows an employer to terminate an agreement before it starts. There's no case law to the contrary of that. The trial employment, in my mind, states essentially you're not employed for a definite period of time. We will give you a trial at best, and if on the first hour you, employee, think we're a bunch of jerks, or alternatively you show up as a doctor unprepared to handle doctor chores, the employer can terminate the agreement. And what it does is, to me, it states that this is not an employment for a definite period of time.
So you're reading trial to mean this is an at-will contract for 90 days, but 90 days really isn't, you can't rely on it because it's at-will.
Correct.
So although your argument is that although on its face the emails may express a definite term, and I don't mean this to be disrespectful, that's really illusory because it's at will.
Now, well, the emails state 90 days, but it's qualified by the term trial.
Which in your mind means at will during those 90 days.
Yes, and other courts have held that. The Leo Meister case out of Massachusetts.
Yes, but they didn't deal with a statute like our
No, they
statute
didn't.
deals.
No question about it. Didn't deal with the EPA.
So, I mean, it does. I'm sorry. Were you done, Diane?
Okay.
What do you do? I mean, assuming that there's there's this issue of, well, we set a trial, that makes it at will, so it doesn't, you can't enforce it under the EPA. What do you do with the other language of the agreement that says transitional period after the initial 90 days? If you're comfortable in the position and we feel your progress is satisfactory, we would do the following for an additional 90-day transitional period. I mean, doesn't that create an issue of what was just on the language of the agreement, not looking at anybody's intent, not looking at Taylor? Doesn't that create at least a fact issue about, well, okay, they're assuming that she's going to be there for 90 days, and at that point, if you're uncomfortable, or if she's uncomfortable, or you have determined she hasn't made satisfactory progress, that's when it ends.
That goes forward on the assumption that there is a 90-day, in fact, definite period of time.
Well, I'm asking,
Yeah.
that's what I'm asking. Doesn't that imply that there was a 90-day definite period?
Well, from that analysis, I think you can certainly draw the conclusion that that might create a material issue of fact, which would preclude summary judgment. But the final, go ahead, Your Honor.
No, go ahead. I don't want to.
What I'm suggesting is both under Taylor and Johnson say these ingredients to meet the statute have to be in the written contract. And if they're not in the written contract, you can't gain those by implication, inference, or question of fact. And go ahead.
No, go ahead.
No, you've got a question on your mind.
I guess, here's my other question for you.
You said summary judgment would have been inappropriate if we read into that second transitional period that, yes, here's a question of fact about whether that first 90-day period was meant to be at will or not, or was at will or not. But I guess I don't see, and I may be wrong on this, but I don't see you are arguing down below or on appeal that issue, that there was a material issue of fact which precluded summary judgment.
You're correct, Your Honor. That was not an argument made obviously not by the plaintiff, but it certainly wasn't made by us, because our premise is the statute has certain ingredients that have to be met,
right,
and they weren't met here, and therefore we don't get to that question.
So if we but if we disagree with you, what do we do? What if we say, gee, we think it met the requirements of the statute, then do we just affirm?
Well, I think if it was based on a question of fact, which the court sua sponte sees, then I think it gets reversed. Okay. But the other part of the analysis here is the premise that these emails embodied the entire agreement between the parties, when it was clear that from Antonson's perspective, she didn't think she had a contract. She wanted a written contract, and she listed out in subsequent emails various things that had to be accomplished. And those included who's paying for the malpractice insurance? How many days a week do I work? And that was a conundrum for the arbitrator and for the trial court, because they came up with two different conclusions on the same undisputed facts.
We don't know what the arbitrators, what problems the arbitrator had, do we? What we know is what the trial court.
No, I understand that, but it just demonstrates a difference, because the arbitration, when affirmed, it was essentially the trial court cut back the damages because
in trial de novo.
Yeah, correct. But there were significant materials of fact, including how many days a week do I work, how many hours a day do I work, that were never part of the contract, which makes the contract it's illusory on that basis.
Counsel, let me ask you. I understand your statutory construction argument, but who, in the one way to look at this is, does the phrase initial 90-day trial period fall within the umbrella of the statute? Does that qualify? And the parties view it very differently. Who decides that and how? Is that something the court decides, or is that something a finder of fact decides, or is that a multi-phase process, or how does this work?
Well, under Taylor, it's either in the agreement to make it enforceable or it's not there.
But my question is, what happens when the parties dispute whether it's in the agreement or not?
Well, to me, that's a question of law. It was a question of law under Taylor, and it was a question of law under Johnson. And the question is, does the contract have within its four corners what you need to take the contract out of the statutory presumption?
And a finder of fact has no role in that decision.
No, it's, that's a matter of law for the court.
So you're trying to keep the pristine nature of the statute by saying, we're not going to open this up to factual disputes about what the contract, whether the contract was sufficient or not. It's either in there or not in there, and court, just tell us.
Yeah, Your Honor, I think the analysis is similar to a question on other statute frauds. You and I agree to buy your house. We don't define what your house is. We don't define the terms, and we cannot add that by parole evidence after the fact. I would like, if you have any other questions, I'll try to address them now. Otherwise, I'd like to reserve my time.
I interrupted. Did you?
No.
No, I just wanted to make sure. Okay.
Very well. Thank you, counsel. Mr. Engel.
Good morning, Your Honors. Christopher Engel for appellees Gwen and Brett Antonson, my co-counsel Logan Elia. May it please the court, the Antonson's view of this case is pretty brief. Both parties agree that this case is resolved under the Employment Protection Act of 1996. Under the EPA, all employment is presumed to be at will unless there's a contract in writing setting forth a specific duration of time signed by the party to be charged. And that's exactly what we have here. We have a contract, it's in writing, it says 90 days, it's signed by Red Mountain's CEO.
What does trial mean then? I mean, I don't know if the legislature, as I indicated earlier, my view of this is the legislature wanted something clear, clean, everybody knows their rights when they form a written contract. What now suddenly someone throws in trial period. So what do we just ignore that?
Yeah. The thing with
and I don't mean to, I want to take you to the next step. What if I said 90 days at will?
Then it's at will. Okay. Or at least there's enough ambiguity that somebody should follow up and ask some follow-up questions, you know.
So, because I'll give you the example. I mean, like most lawyers, I think when we hire law clerks, we tell them you will be hired for X amount per year from August 15th to August 15th of that year, but understand that your contract is at will. And so you're saying, okay, that's the exception. If you say it's at will, at least then we know it's at will.
Yeah, I'd say if the contract says at will, it's pretty much at will.
It doesn't have to say
or at least there's a good faith dispute as to which one it is, and maybe that gets resolved.
What do we do at trial?
It's just the name of a time period. Anytime you have a new employee coming in, the first period of employment is going to be called like the introductory period, the probationary period, the trial period. It's just the title that's given to that period. What Arizona law says is if you want to have employment at will, you need to say it's going to be at will.
No, it's the reverse. If you want to have it be at will, you don't put in the specific, don't have either specific duration or say here's your job protection.
There's actually, there's cases on both sides of it saying if you want to.
But the statute says.
Right.
If you don't say anything, if you just say we're hiring you, it's
Right.
at will.
Yes.
And if you say hiring, and I think some of the common law was if you say $50,000 per year, that's still at will.
Yeah.
Okay.
Yeah.
Okay.
And in your argument, if I hear you right, if instead of saying initial 90-day trial period, it said initial trial period for a while, you would lose.
Initial trial period for a while. Yeah, I think I would if it was
the literal 90-day. That's the tipping point.
Yeah, it has to be a specific period of time. It could be 90 days or 6 weeks or 3 years, but it has to be a specific duration of time. And this is as specific as it gets. It's not 89 days. It's not 91 days. It's 90 days.
But doesn't the agreement to a specific term assuming that satisfies the statute, all that does is that renders the contract, that allows a claim to go forward, but don't you need to look at the terms of the contract that the parties agreed to determine whether there was a breach or there was an anticipatory breach? I mean, say the contract had said, we're going to hire you for 90 days, don't wear anything blue. If you wear blue, that would be a breach of contract. She wears blue, she can get fired even though it's 90 days, within the 90 days. So it's not as if it's agreement to a term of time doesn't mean you
I understand where you're going. It's an issue that this case dances around the edges, but it never quite come up, is what's firing for cause. If Gwen Antonsen started her job and she set a patient on fire and punched Mark Benson in the face, they could probably fire her. The agreement then is that they have to employ her for 90 days, and their right to fire her is restricted to only good faith reasons where they could realistically no longer go forward with employment. Now, Red Mountain has never said that Gwen was fired for cause. They've never attempted to raise that or argue it. And the Arizona case law that I've found on that does not support it. Some of the cases I've seen are examples of for cause: abusive language, threat of physical violence against a coworker, being insubordinate.
But she never started.
Correct. She didn't do anything that would have required a for-cause termination, which is why this is an anticipatory breach of contract.
But isn't the word trial, doesn't that have a meaning? Doesn't that give doesn't that give both parties some contract rights?
It does give them contract rights, yes.
What rights does it give your client, and what rights does it give Red Mountain?
It gives Gwen Antonsen the assurance that she's got 90 days to prove herself. She has this initial period. She will do her best, Red Mountain will do their best, and at the end of it, they sit down and they assess.
How do we know that's what that means?
Well, that's what Gwen testified that she understood it to mean, and that's frankly what it says. It says after 90 days, we're going to sit down and assess.
Okay.
Well, the thing is that if they want employment to be at will, they need to say the words at will. And they admit that through the entire negotiations, those words never came up, not once. They
don't have to. They don't have to accept that. They said 90 days. Like I said earlier, and the statute says, if you don't say anything, it's at will. It's presumed at will. Right?
I understand.
But
yeah.
you're saying that once they said 90 days, if they wanted to be at will, they had to say at will. That's your point.
Correct.
So you're saying that your client testified that trial period of 90 days meant her performance would be assessed at the end of 90 days. Was there evidence offered by Red Mountain that no, a trial period meant the other a hypothetical meaning that I laid out earlier, which is you make a mistake in the first 90 days, we can let you go?
No, Red Mountain didn't say that. They said that they thought they could fire her at any time for any reason, not if she made a mistake, simply because they want to.
Well.
So that was their testimony on that issue.
So what do we do with that? We've got language that we all can read that doesn't neatly square with the statutory provision. We've got record testimony by the parties saying they each construed it differently, given the nature of trial period. We have case law saying that the secret or subjective intent in construing a contract really is sort of a ho-hum. It doesn't matter. That's not how you construe contracts. And we've got, I think, both parties saying that this is appropriately an issue of law that the court decides. I have a difficult time sort of making those talk to each other.
Well,
so help me out.
You should affirm. The objective manifestation of intent to a contract controls, and that's the Hill-Schaefer Partnership case, Harvard v. Industrial Commission, and Lerner v. Brett Schneider. A secret, unvoiced, subjective interpretation that's never come up can't be used to vary the plain meaning of the contract.
That's true for both sides.
Correct. This contract says 90 days.
It also says trial period.
Trial period is not synonymous with at will. See, the words at will aren't in here, so what Red Mountain is trying to do is add them in. Oh, this word trial, of course it means at will. They're the same thing, so the words at will really are in there.
Let me ask you, though, to point that a little bit, and I'm reading from the statute, because it says shall remain, so that the written contract which provides, and this is to come under the umbrella of the EPA, that the employment relationship shall remain in effect for a specific duration of time or otherwise expressly restrict the right of either party to terminate the employment relationship. And I think the record's clear that that second clause, otherwise expressly restrict, really isn't in play here. But the first is, shall remain in effect for a specific duration of time. And what I think we are asked to struggle with is whether the, and I think it's 5 words, initial 90-day trial period falls under that protection. And appellants have made arguments that trial period is what we should focus on. You appropriately ask us to focus on the 90-day chunk. It's neither fish nor fowl in some respects.
What Red Mountain wants to do is, I call it the magic words argument. They say, well, the statute says must remain in effect for a specific duration of time and is contrary to the at-will employment relationship. They say those words have to be in the contract or it's at will. Now, those are the words of the statute, but the statute doesn't say you must use these exact words, and no case has ever held that. What the statute requires is just a specific period of time and saying, hey, we're going to give you a job for 90 days. It's the trial period, and then we stop and see how you're doing. That's a specific period of time. It meets the statute.
And so doesn't that, though, require us to effectively remove the phrase trial period from the contract? And aren't we kind of prohibited from doing that?
You don't have to remove it. It's just a title that's given to the beginning period. If they had called it an initial period, a probationary period, initial period of 90 days, probationary period of 90 days, trial period of 90 days, they're all periods of 90 days. What Taylor shows us is that it doesn't matter what you call it. The title that's given to these time periods are not dispositive of at will or for term. This contract is for term. It's specifically 90 days. It doesn't matter if she's a trial employee, probationary employee, regular employee.
Well, see, for me, it's if trial means what they say it means, which is that they could let the employee go for any reason within those 90 days if she didn't work out or for any reason, then to me, that's determinative because to me, she's at will, because that's what at will means. If your meaning controls, she has 90 days to prove herself, then it's a definite term. To me, the meaning of trial determines whether the statute applies. And I'm wondering what we look to. Perhaps we look to the fact that no right-thinking person would move across the country to take a job that might last one day. On the other hand, trial period is interpreted by several cases to mean if you make a mistake, you can be gone. Does it mean, though, does it mean you have to make a mistake before you can be gone? Trial period might not mean at will, because at will means you could be let go for any reason. It's a pickle. And you're telling us, both sides are telling us it's a matter of law, and we're pointing out the difficulty with that.
Well, and let's narrow in on that. So juries decide questions of fact. Who said what? Of these two competing witnesses, which one do we believe? What actually happened here? And in this case, we agree on all the facts. This is the exact email that was sent. This is the exact words. So interpreting whether those words bring it within the penumbra of the statute is a question of law.
Well, okay. Did he answer your question?
Well, I'm just saying that perhaps your best argument to help us understand what the trial period means, is that a trial period is a period under which your performance will be measured. And maybe that's something different than we could let you go for any reason that's not a bad reason, which is the definition of an at-will employee. So maybe there's a middle ground there.
I think if it just said a trial period, that would probably be the same as at-will employment. It's the 90 days.
Well, I understand, but I don't want to put words in your mouth. But if I understand what you're asking is that if they use the word trial period, 90-day trial period, it is something that's not per se at will, not equivalent to at will, but it's something that, well, you got 90 days to.
You've got some rights. You can be let go if
you come in and commit malpractice and a patient dies under your care, that's probably for cause. We're not saying that, but it's something more than, well, we can't just release you, fire you because we don't like the color of your hair or for no reason at all. We're going to give you 90 days to show that you can do something, that we're happy with your performance. Was that your point? Like, I don't mean to ask you a question. I apologize. I shouldn't ask you a question. But I want to add on to that. That's why I asked. I want to add on to that. What do we do with that second transitional period? Doesn't that second transitional period seem to mean after the initial 90 days, if you're comfortable in the position and we feel your progress is satisfactory? Doesn't that seem to indicate that unless you do something that's really horrible in that 90 days, that we can fire you for cause, that we're going to give you 90 days to make things right? Or, for instance, let's assume she was doing great. Let's assume she was bringing in business, all the clients were happy. They want to make sure that she's going to be there for those 90 days. If she turned around and said, I got an offer from one of your competitors, and after 30 days, I'm leaving. Doesn't that, that seems to indicate if you're comfortable in the position, we're going to evaluate everything after 90 days. So doesn't that seem to imply that we don't need to decide what do you do when you have language that may or may not make it fall under the statute? This seems to make it fall under the statute. That trial period didn't mean it's at will.
The transitional period does contemplate that she is there for 90 days and then they stop and assess. The reason why we never move forward on that is because they never let her even start the job, so we don't know.
I understand that, but I'm just saying that if both of you, the conundrum we have is one person says it meant 90 at will, the other person says because it says trial, the other person says no, it doesn't mean a trial because it says 90 days, so it falls under the statute, so it's not at will. And which is normally a fact question, and you're both telling us it's a matter of law. And what I'm saying is, well, maybe it's a matter of law. There is no fact question because we don't have to decide what happens if there's a fact question, because there's another provision that seems to imply that for 90 days, you have some security for 90 days unless we have cause to fire you. We can't just fire you at will.
Yeah, that's the exact same way I read this contract. It's how I understood it. It's how Gwen understood it.
Right. But given that seemed, to me at least, it seems that second period seems to support that view.
I would agree, Your Honor.
Mm-hmm.
I had an entire, prepared speech to go through. I'm not going to get through all of it now. Is there any other specific questions we'd like to hit?
Well, talk to me a little bit more about the notion that I understand what Red Mountain to be saying is that a 90-day trial period means is effectively an at-will period of 90 days, that the employer could let the employee go for any reason that's not a bad reason under Wagenseller. My question is whether there's a middle ground between that interpretation and the one that you said your client testified to, which is that I get 90 days to prove myself. Could the middle ground be I am on trial, I'm in a trial period for 90 days, which means that if I mess up, or if I do something that would normally get a probationary employee let go, then I can be let go. But I'm not at will during that time period. In other words, I can't be let go for any reason. I could be let go if I make a substantial mistake. Is that one way of interpreting what a 90-day trial period is?
Yes, Your Honor, and I'm sorry if I didn't make that clear. Yeah, I think that's exactly what it is. If it were at-will employment, it's we can fire you anytime, any reason whatsoever. Then you get this contract where it's 90 days. Well, does that mean she can do anything she wants and they have to continue to pay her for 90 days? No, I think it means that after that, they can only fire her for cause, something that makes it nearly impossible to continue with the employment relationship. If she was insubordinate or punched somebody in the face or was cursing at a supervisor, those might be terminations for cause. And I think that in that situation, they could terminate her even inside that 90 days. It'd have to be termination for cause. What they've done is they've restricted their ability to, or they've contracted away their ability to fire her for any reason whatsoever.
Right, but they could fire her if they determine after 2 days that, boy, she's horrible. She's a horrible doctor. We don't want her here because we know already. Arguably, they have the power then in a 90-day trial period to let her go then.
Yeah, it'd have to be pretty severe.
Right.
I mean, it'd have to be a good faith, serious violation that makes it impossible to keep going forward. But if something like that had happened, yeah, I think that would probably be valid. One of the things that sticks out to me is that if this is truly at-will employment, as Red Mountain says, and you're saying, well, what's trial? Is that irrelevant? Well, if it's truly at-will employment, then 90 days is irrelevant. They say, hey, start with us. It's at will. What is all this stuff about 90 days and then a review and then another 90 days and then another review? All of that becomes meaningless. They can just say, well, if everything looks good, then we'll give you a permanent position. If it doesn't work out, then we'll let you know. So at any rate, I see I'm out of time. I'll just summarize. The Antinsons believe that this claim is very straightforward under the EPA. It's a contract. It's in writing. It's signed by the party to be charged. It's for 90 days. They didn't even give her a chance to start. They breached before she ever even started the job. So I don't think we get into the, for cause termination. That's not been argued or briefed. Thank you for your attention.
Thank you, Mr. Ring. Mr. Patterson, rebuttal.
Yes, I think what the EPA sought to do was to simplify this employment landscape for both employers and employees. And it sought to simplify it by saying at will is presumed to be employment in Arizona. You don't have to state it. And the case law, Taylor and Point, says it is now, and it switched it, it's now the employee's burden to prove that there's something other than at will. That was contrary to what the law had been before.
And that makes sense, but the offer, had it said this is an employment at will, could have eradicated this entire dispute.
No question about it. But unfortunately or fortunately, business people don't drag around lawyers with them every time that they stand up and order lunch for fear that they're going to say the wrong thing.
I understand.
And so that brings us to where we are today. But the important point about both the context of using the word trial and interpreting the statute is that you can't render these words superfluous. And the argument here is the use of the word trial is superfluous, analyze the contract as if it wasn't there. And the other thing the trial court did was it struck the specific language that says the written contract, I think we all agree we need a written contract, must set forth that the employment relationship shall remain in effect, then you add the days. What the trial court did and the arguments that I've heard here today render that language totally superfluous. And it had a meaning. The legislature said, as the public policy of the state of Arizona, as well as the governor at the time, this has to be in the contract. If it's not there, then the presumption is at will, end of story.
So
you would need a lawyer every time the employer wanted to hire somebody, because if they said, hey, this guy's going to be a key employee of mine for a year, I don't want him turning around and saying, I can leave after 6 months. So I better talk to my lawyer and have my lawyer say, well, yeah, I read that. You better say in that contract, don't say that he's employed for a year. Say that that this contract will be in effect for 1 year. Is that what you're saying?
Well, what I'm saying is the statute says what the statute says, and what it does say is that the contract must set forth that and state that the employment relationship shall remain in effect for 1 day, 90 days, a year.
So shall remain in effect needs to be in the contract? Is that what you're saying?
Yes, I think it does. And I think that's the import of Taylor. Taylor and Johnson both say on the other side of it, where either party is prohibited from termination, that's got to be expressed in the contract. You can't leave that to inference. It can't be a factual inference that a trier of fact draws. It's got to be in the contract. And our argument here is it's got to be in the contract. To your question, Judge Kessler, it's both probably a sociological and a philosophy question, as well as a legal question. But the real point is, I think, from the way the statute is written, from the way Taylor interpreted it, the way Johnson interpreted it, the contract has to have these terms in order to negate at-will employment. It simply does not have the terms required by the legislature and the policy statement from the EPA.
So you're saying that even if it just said 90 days,
Correct.
we will hire you for 90 days, that's not enough?
No.
Okay. It's got to say, this contract shall remain in effect for 90 days.
Or alternatively, neither party can terminate the agreement. And they're essentially two ways of saying the same thing, but they're both saying it's got to be in the written contract. And I think, regardless of the philosophy, sociology, etc., I think that's clear. And it's clear in the statute. Because the words, the written contract shall set forth, da-da-da-da-da-da, is what the statute says. And it's really, quite frankly, it's no different than some of the contracting statutes that at face value may seem harsh. Like, you don't have a contractor's license at the date you entered into the contract, but you had one when you did the work. Too bad, so sad, you don't get paid. Are there any other questions I might entertain from your honors?
Thank you, Counsel. I don't believe so. Counsel, we appreciate your briefing. We appreciate your oral argument today. We will take the matter under advisement. We'll issue a ruling in due course. Court stands adjourned.